SJC 12422, Christopher Anderson and others, v. Maury Healy and another.
Mr. Martin, good morning.
Good morning, Your Honor. Mr. Chief Justice, and may it please the Court, Kevin Martin for the appellants. With me today I have David Zimmer and Joshua Bone. Your Honors, Article 48 allows the Constitution to be amended by initiative petition, but only subject to limits which this Court strictly polices in order to safeguard the legislature's authority and to safeguard voters from abuses such as log rolling. The challenged initiative violates 3 such limits and therefore must be excluded from the November ballot. I would like to start with the initiative's violation of Article 48's related subjects requirement, which this initiative violates in 2 separate ways. First, it violates it by grouping together 2 unrelated subjects of spending as the subject of an earmark. And second, it violates it by combining that earmark with an entirely separate public policy issue, whether to amend Article 44 to impose for the first time in the Commonwealth's history a graduated income tax.
Well, there's no requirement of a single subject. And if I could recast the Attorney General's position, why wouldn't it be that in a thriving community, education, transportation, they're twin pillars of a thriving community? Why can't voters take a look at that, take a look at a tax increase on individuals who are doing well and say that's a single policy?
Well, so Your Honor, I find it telling the Attorney General did not make that argument. The Attorney General's argument contained no argument linking transportation and education together. That argument was made by the proponents, and that argument needs to fail. The way this Court has articulated the test in cases such as Gray is whether there are multiple public policy issues joined together in a single initiative. And here, whether to have an earmark which is dedicated in part or whole to transportation, in part or whole to education, to the exclusion of every other pillar of an economy, such as affordable housing or affordable energy. Those are 2 separate public policy issues. Anyone who's been through a override campaign at a town knows that education is a very controversial subject, and raising taxes to pay for education is a controversial subject. I assume transportation is no less controversial. I'm sure there are people in the Commonwealth who do not use, for example, the MBTA or don't travel the Mass Pike, who would be opposed to raising taxes for that subject, even if they were in favor of additional taxation for education. If there's going to be a dedication in the Constitution where it cannot be amended by the legislature to certain transportation spending or to certain education spending, that should be considered by voters separately so that voters do not need to cast a single vote on those 2 very different subjects. And I would point, Your Honors, to cases such as Kearney, where there were two parts to the initiative, both of which dealt with the welfare of dogs, an extremely specific issue. Nonetheless, this Court found that they were 2 distinct, that there were voters who might be in favor of one aspect of that initiative, but not the other.
Well, animal cruelty is a lot different than greyhound racing.
Well, there are those who think that greyhound racing is cruel to greyhounds. That's much of the impetus behind outlawing the sport.
Criminal penalties for animal cruelty is a lot different than whether or not there should be parimutuel betting on greyhounds.
Well, they are different, Your Honor, and that's why the Court kept it off the ballot. And for example, in the Gray case, this Court found that the issue of Common Core was a separate public policy issue from the question of the MCAS. And so again, an initiative which tried to combine those was kept off the ballot. We would say there's no less of a difference between funding teacher salaries on the one hand and repair and maintenance of train lines.
So your argument would be, the Attorney General's trying to connect anything. They could connect anything under their theory, right? They could have connected solar power, pension reform, right? There are really no limits.
That's exactly right, Your Honor. And what this Court has, again, said in cases like Gray and Kearney is that at some conceptual level, any 2 issues can be tied together. But
So how tightly do the funding, so we've got a tax increase and we've got a policy expenditure. Do they have to be completely connected? I'm trying to figure out how tight the connection needs to be.
We believe they need to be tightly connected enough that somebody looking at the package could identify a common core which dominates the separate aspects of the initiative. And when you look at the cases in which this Court has previously allowed an initiative to go through with both revenue and spending components, In every single case, the revenue was being raised from a particular type of activity and was being spent on issues pertinent to that activity. So, for example, you have the Hensley case in which a retail marijuana market was being set up and would be taxed. The tax on marijuana sales would then be used for the regulation of the retail marijuana market. You have other cases in which there are forfeitures for drug crimes, and the money goes into a fund for treating drug addiction, or money is raised from employers in order to pay for workers' compensation.
So have we ever separated that, where we have unconnected or not closely related expenditures to the program?
This court has never seen such a case, Your Honor. This is a truly unprecedented initiative.
Wait a minute, what about Proposition 2.5? That survived a relatedness objection, didn't it?
And so what the common core that the court found in that case, Your Honor, was that every aspect of that was designed to lower the tax burden on the citizens of the Commonwealth, and that was deemed a sufficient enough core to survive. That has no relationship to a situation in which you're raising money on every single type of economic activity which could be occurring in the state, and then funneling it only to two specified purposes, which may have no relation whatsoever to the source of the revenues.
Well, don't you see that there could be, as the Attorney General points out in their brief, that there could be a unified public policy behind these two areas for expenditure? Is there a unified, I mean, they're arguing there's a unified public policy in terms of infrastructure and education and the well-being of the Commonwealth.
And they do, but that's simply too broad a topic. Almost any expenditure that the state government makes arguably goes toward improving the welfare of the citizens of the Commonwealth, and the vast majority, I mean, you could characterize basic health spending as important to the economy of the state. A ill workforce is not a productive workforce. So a common purpose, which would sweep in essentially every topic of government spending, is just too broad.
Can you address the concept of operational purpose?
And so where the court has talked about operational purpose, this goes, for example, to the Carney case, in which you had a administrative law topic and you had a criminal law topic. Here, there's no operational link between transportation and education, certainly. And there arguably could be an operational link between revenue and spending, but in this case, those are, in the words of Gray, two very different public policy issues. Whether to amend the Constitution so that we have a graduated income tax for the first time in the century is an extraordinary public policy question. It's something that's been put to voters separately 5 times, and every single time it's been put to voters as an independent issue, voters have voted it down overwhelmingly.
How important is the past, that it was previously rejected when it was an individual item?
So what that goes to, Your Honor, is what this court has said in Carney is the court's ability to use its common sense in considering these issues.
So the fact that it's been rejected in the past is indicative of log rolling?
It's indicative of log rolling, and it's indicative of the fact that standing alone, it's a independent public policy issue which deserves independent consideration by the voters of the Commonwealth, and it should not be grouped together with two subjects of spending which themselves are independently present public policy issues that the public should consider.
Let's walk through that. Graduated income tax was proposed, defeated. Analysis could be the public doesn't want to give the legislature the authority without limitation to impose graduated tax, so they narrow its scope and they say, we're not going to ask simply for an unlimited power to impose graduated taxes. We're going to limit it to 4% for income over $1 million. Can they do that?
That cannot be done, Your Honor, for the reasons we addressed in our third argument in this case, which is that...
And if they can, why can't they limit the scope of graduated income taxation and say it's not going to be unlimited graduated income tax, it is going to be limited in a particular way so as to address public concerns that giving the legislature that authority may lead to excessive taxation for certain groups?
Your Honor, I believe a ballot question like that would need to come either from the legislature, to which the limits of Article 48...
Where in Article 48 does it say you can change Article 44 to provide for graduated taxation, but you can't narrow its scope and provide a more precise definition of what the graduated income tax would look like.
And so where we find this, Your Honor, is in the court. The court which best knew the events of 1917 to 18 would have been the court of 1937, which issued the opinion of the justices that year. In that decision, what the court said, looking at Article 48...
So the court that best knew what happened in 1917 was the Supreme SJC in 1937, 20 years later?
Well, of the courts which have considered these issues, what the court in 1937 said, looking at Article 48 and looking at Article 63, was that it was clear that the ways and means of the Commonwealth were intended to be left to the legislature, notwithstanding Article 48's initiative petition process. And in the 1937 case, that manifested itself in a decision which said you cannot have a constitutional amendment which ties the legislature's hands with respect to spending. And we would look at that same precedent and look at Article 48's assumption that it will be the legislature which raises taxes, and look at Article 63's establishment of a unified budget process for the Commonwealth, in which the legislature must match revenues to spending, and look at the debates in 1917 to 1918, in which the delegates were very concerned about measures which might, in their words, knock spots out of the budget and prevent a real unified budget process, as demonstrating that just as the subject of spending cannot be addressed in the Constitution in a way that ties the legislature's hands, so too the subject of taxation should not be addressed there.
They may have been concerned, but not so concerned as to add it among the many exceptions to Article 48 that they did include.
That's correct, Your Honor, but in this regard, too.
Where it was not added as one of the many exceptions to Article 48, where is our authority to say that's what they meant to do and didn't do it, or that would be wiser for them to have done it and we're going to do it for them?
And so what I would point Your Honor to in this regard is the court's decision in 1970 in Cohen versus Attorney General, which goes directly to the question Your Honor just raised. In that case, the question was whether law in Article 48 would include a statute calling a constitutional convention, which is how every prior constitutional convention had been called, by statute. Even though Article 48 does not have an explicit exclusion on statutes calling constitutional conventions, nonetheless, the court looked back at the history of 1917 to 1918 and what the delegates said during the extensively recorded debates during those 2 years, and read an exception into Article 48 under which you cannot have a statute calling a constitutional convention. There was a 3-justice concurrence in that case in which the Chief Justice, joined by 2 others, noted that the plain meaning of statute and understanding of statute and law in Article 48 would include a statute calling a constitutional convention. Nonetheless, based on the understanding of the delegates in 1917 to 1918, they were going to read that out. And so we would go back again to the 1937 decision and the court's statement in that case that ways and means were both left to the legislature, notwithstanding Article 48, as evidence and a conclusion by the justices who would have experienced that constitution within their life, that convention within their lifetime, as demonstrating that just as spending cannot be addressed in the Constitution by initiative petition, so too taxation should not be.
So let me turn you back to your related questions. Right now, the legislature expends roughly $20 billion in education and transportation, I gather. If this initiative amendment is allowed to go forward, and if it were to pass, it would dedicate approximately $2 billion, I gather, to education and transportation. Am I correct that if all of that were to happen, the legislature need not expend any more than the same $20 billion they're expending today, because they could simply dedicate the $2 billion to education and transportation and cut back on the $20 billion they presently are expending and expend only $18 billion?
Yeah, it is true, Your Honor. There's absolutely no guarantee that if this amendment passes, that a single penny more will be spent on education and transportation.
And the Attorney General argues that shows why this is constitutional in terms of not creating an appropriation, because it's, what do you say to that subject to appropriation language? Right,
and so, Your Honor, money was no less fungible, as Chief Justice Gantz was just discussing, in 1937. Nonetheless, in the 1937 case, the government could have taken the money raised from transportation taxes, dedicated it to the purposes specified in the amendment that was struck down that year, and withdrawn money that otherwise would have been spent on those subjects. Nonetheless, what this court found was that putting any kind of limit on the legislature's ability to spend even a pool of funds in the Constitution was a violation of the specific appropriation clause. There was some debate in the briefs about whether the 1937 amendment actually directly appropriated money to the executive branch. There was a suggestion in the intervener's brief that the amendment sent money directly to the Highway Department. As we've noted in our reply brief, that's actually not the case. The amendment that was reviewed by the court that year allowed the money to be spent by the Highway Department as well as by any other department that had jurisdiction over highways and bridges. It could be spent on the police who were patrolling the highways. It could be spent on by the Revenue Department for the cost of administering the taxes, and it could be spent on debt service. The problem there was that there was a limitation on purposes placed on the legislature in the Constitution. That alone is sufficient to run afoul of Article 48. And as to the specific appropriation argument, which is made by the appellees, that would, as I understand the Attorney General's brief, there is absolutely no restriction placed on the legislature's ability to use this money at all, not even the type of restriction that the Chief Justice was referring to. The legislature would have plenary authority over the money. That is clearly not what this proposed amendment says. It's not what any other party in any brief has said it says, and it's not what the Attorney General's own, I think, description of the amendment for voters says that this amendment does. If you read subject to appropriation in this constitutional provision to essentially untie the legislature's hands, then you're rendering the language only for specified transportation and education purposes.
Well, aren't they making a narrower argument? They're saying that they're limited to two giant pots, basically transportation and education, but they're not forcing a specific appropriation. It's not targeted to, building high-speed rail or something narrow, right?
Well, they make that argument too, Your Honor. Again, that was no less true of the amendment in 1937, which was struck down by the court. That allowed spending on any highway purposes, on policing, on debt service, on certain costs of tax administration.
But we've added a bunch of cases where we include this language if it's subject to appropriation. I know there's an Ipsy-Dixit quality to that, but we've said that if you include in the initiative that it's subject to appropriation, it isn't subject to appropriation, right?
And Your Honor's right, there is a certain Ipsy-Dixit quality to that. But as the court's also pointed out, in all of those cases, which were statutory cases, not constitutional cases, the reason why it has an Ipsy-Dixit quality is that when you say money dedicated by a statute is subject to appropriation, all you're doing is reminding people that the statute's always subject to amendment or repeal. The same is not true with respect to a constitutional amendment. And this court could not have been clearer in its 1940 Evans decision, issued only 3 years after opinion of the justice's 1937, that makes all the difference in the world. Because when you have a constitutional provision earmarking funds, the legislature is bound to spend the funds on the subject to which they've been devoted. Otherwise, it cannot spend them at all.
I want to sort of get to that point for a minute and get beyond the three reasons that you say the challenged initiative petition violates Article 48. You talk in your brief about this initiative petition being of constitutional dimension, but there's nothing different about the process that the AG goes through. It's just you're saying the result of a constitutional initiative petition is of more gravity. Is that right?
It's not just that the results have more gravity, it's that the impact of the same language is different when it appears in what Evans called a mere statute subject to legislative amendment or repeal than when it appears in a constitutional provision which the legislature cannot unilaterally amend or repeal.
Meaning the legislature can just void the statute and not spend the money. But with the Constitution in place, you're going to collect the money and have to spend it on one of these two provisions, right?
Either you can spend it on those two provisions or not spend it at all, Your Honor, and that's really what Evans focused on. And this court returned to that very same notion in the AIM decision in 1992 and said you cannot ignore the constitutional dimension of the 1937 measure in comparison to the mere statutes that the court was dealing with an AIM.
Well, that's the question I'm trying to get to, which is put aside the three reasons for under Article 48 for challenging the initiative petition. How is it that the fact that this proposed initiative petition is of constitutional dimension change our analysis?
It changes your analysis because the delegates in 1917 to 18 were very concerned about the legislature's hands being tied. When it's a statute, the legislature's hands aren't tied. When it's in the Constitution, they are. And that's why you have a different result in the 1940 Evans case than you have in the 1937 opinion of the justices, because the latter was a constitutional provision earmarking funds. The former was what this court referred to as a mere statute. And again, the court noted it and explained at length in 1992 in AIM that reasoning continues to hold.
What's the difference between the initiative that was disallowed in the 37 case and the Article 104 of the amendments that had the same subject matter but was allowed to be an amendment to the Constitution?
Sure, and so as we recount in the briefing, Your Honor, the history here is very important. Article 104 did not spring forth from an initiative petition. It was really just an amendment of Article 78 in the Constitution. Article 78 in the Constitution was originally introduced by the legislature as a legislative constitutional amendment. Legislative constitutional amendments are not subject to the Article 48 subject matter restrictions. Those only apply to initiative petitions which originate with 10 voters. So you have Article 78, which puts in place broad restrictions on the legislature's use of certain transportation taxes. It's not challenged because there's no basis under Article 48 to challenge it. Article 104 comes along, and it actually adds an additional subject to the permitted subjects of spending under Article 178. It loosened pre-existing restrictions on the legislature rather than introducing a new restriction on the legislature, and it drew no challenge. Nobody thought to bring a case saying you cannot loosen bounds on the legislature. And I would note the Attorney General did not join that argument, which was made by the proponents of the initiative.
Now, pragmatically, if this amendment were to go forward and to pass, $2 billion would be dedicated to transportation education, correct?
Roughly, Your Honor, yes. And to certain transportation, I would note. There are limits even within the transportation category
Okay,
where it
but
could
it
go.
could be spent on roads, it could all be spent on roads, it could all be spent on public transit, it could all be spent on pre-school education.
Correct, Your Honor.
But I think you're probably correct that $2 billion would be dedicated to that purpose, and if they're not spent for that purpose, they would have to sit until they were spent for that purpose. Is that your understanding?
That's our understanding of this initiative, Your Honor.
But is it of any consequence that the legislature would almost have to spend $2 billion on education in any way in view of the constitutional obligation to cherish education?
We don't view this as significant, Your Honor. Again, the 1937 initiative, there's no record, for example, that in 1937, the amount of taxes in question would have been so much that there would have necessarily been an increase in highway spending
But
or debt spending.
we can take judicial notice that that's the case here, can we not?
You can take that notice here, Your Honor. I'm just not sure it makes a constitutional difference because the principle, and what this court repeatedly has said, is that the essence of a specific appropriation is that it removes from the legislature's hands the decision how to spend certain public funds.
But here it doesn't, because the legislature would have to spend $2 billion because of its constitutional obligation to education, and nothing bars it from moving the other $18 billion to health or to other purposes.
Your Honor, I'm actually not sure that the legislature would have to spend $2 billion in education because you could imagine a scenario in which local property values rise to a level that you don't need state funding.
That might be, but certainly it's not. We cannot reasonably expect that the legislature is going to spend less than $2 billion in any event on education and transportation combined.
That may very well be so, Your Honor. I would note the danger here is as much from this particular initiative as from what a precedent allowing this on the ballot would do, which is to encourage every special interest group in the Commonwealth to try to get some piece of public spending set aside for itself in the Constitution where the legislature cannot touch it. And when you have not a single initiative setting aside 5% of state revenues to a particular purpose, but 10 constitutional provisions carving up almost the entire pie, then you have exactly the scenario that the delegates in 1917 to 1918 were concerned about, which is the dedication of public funding on a piecemeal basis outside the control of the legislature. And the word piecemeal is one that jumps out, and I think this court has focused on in prior decisions. They wanted a real budget process, and a real budget process in the hands of the legislature is not one in which any 10 voters can go to the people and without the ability to have legislative committees consider the impact of sending money one direction or the other, you suddenly have constitutionally binding commitments of money to particular causes that this court and the lower courts will be asked to enforce. That's not a budget process, and it's particularly ripe to the kinds of abuses such as log rolling, which concerned the delegates in 1917 to 1918. Here we have a scenario in which people are trying to get through a graduated income tax for the first time in our Commonwealth's history, and they're tying it in voters' minds to two subjects of spending, which, as the court has noted, the money may not even go to. There may not be a single penny's increase in spending for those causes. When you allow this to be done through initiative petitions, you're triggering the very risks that the delegates in 1917 to 1918 intended to avoid, and there's no reason to do it. If you want to have a graduated income tax, there's a way to do it. You can either have do what was attempted to be done in 1994, which is have a constitutional amendment giving the legislature authority to set a graduated income tax, and then a separate initiative petition at the statutory level saying what the rates will be. You can do it that way. If you want to, you could do it through a legislative constitutional amendment, which is not subject to Article 48's subject matter restrictions. However, what they are trying to do here is precisely what Article 48 prohibits, which is to, through the initiative petition process, tie the legislature's hands with respect to both spending and taxation.
Can I take you back to the related point for a second? Say we don't agree with you on your first argument that you can't do this type of tax increase through the initiative process, but we need to have a working principle on relatedness. So does the tax increase have to have some close correlation to who's being taxed or the increase, or is it just unlimited? I'm just trying to understand, if we don't buy your first argument, how do we interpret the relatedness requirement?
So, Your Honor, I think the relatedness requirement was well stated by the court in cases such as Carney and Gray and Abido. Mm-hmm. First, you ask whether there's some common core to the initiative, which dominates.
If we had this tax increase and it was limited to education, for example, would that satisfy it because there's only one possibility? I understand education and transportation have a relationship that's only very abstract. But would a single big item pass that test?
We don't believe so, Your Honor. And in particular, if you look at the gloss that Gray put on this test just a couple of years ago, really the court should use its common sense and ask if there are multiple public policy controversies at play. And if the question is, are we going to have a graduated income tax for the first time ever, and are we going to dedicate billions of dollars to just one particular purpose, whatever other pressing needs the Commonwealth may have, those are two sufficiently independent public policy questions that voters should be asked them separately, if at all.
All right, thank you.
Thank you, Your Honor.
Ms. Cook, good morning.
May it please the court, my name is Kate Cook, and I have the privilege of representing the original signers of this petition. I plan to argue for 8 minutes, and Attorney Rice will argue for 12 minutes. Article 48 of the Massachusetts Constitution strikes a delicate balance between direct democracy and representative democracy. The original signers asked the court to continue to protect that carefully calibrated balance and to allow this question to go to the voters. And if I may,
What's the closest example to this? Because we've found the relationship between a core curriculum and issuing standard tests to be too unrelated. We've found protection of animals from abuse and closing down racetracks to be too unrelated. You're connecting a progressive income tax to paying for education and transportation. Those seem to be three separate major policy decisions. What case is closest of ours to that?
I would turn to just 2 years ago, both Dunn and Hensley, where the court found the petition, so long as they, all aspects of the petition had an operational relationship to the Unified Statement of
What does
Public
that
Policy.
mean, operational relationship?
I read it to
Because
mean
you
that,
related operationally, or
Pardon me?
because the proposers connected makes it related, or?
as I read the court's decisions, it's a objective person standard, looking at whether the aspects of the petition relate to the goal. Here,
Seems
our
so,
goal,
please finish, I'm sorry.
I was just,
Go ahead,
that
finish,
the
I'm sorry.
Unified Statement of Public Policy in this petition is to impose a tax on high-income earners to provide new revenue for transportation and education. All aspects of this petition relate to that policy. And as the court said and done just 2 years ago, when the court is analyzing a relatedness, a petition on a relatedness challenge, we look to what the framers were seeking to avoid with establishing the requirement.
Dunn seems so different, though. Dunn deals with farm animals and whether or not they can be caged, and then the next part of the petition deals with whether or not if somebody, in fact, has farm animals in that condition, whether or not the product can be sold. It all has to do with the same thing. And it seems like Hensley has to do with marijuana. Marijuana can be legalized, can be taxed, can be regulated. Here we've got increased taxes, and then we have, which we've seen what's happened before with petitions here, and now we have two things that are mother and apple pie. We've got education and we've got transportation tied to it. So I'm not having a hard time getting Hensley and Dunn around this.
We see this as a unified public policy.
But
The
whose
tax
unified
doesn't have-
public policy is it? I mean, because you could articulate that as not a unified public policy depending on your particular interests. If
What-
you're interested in transportation, or if you're interested in taxation, or if you're interested in education.
I think in order to analyze whether the petition meets the relatedness requirement, we start with looking at the fact that this court has said there's no bright line test, and so what one should do is ask certain questions to get at whether this presents any of the evils of what the framers were seeking to avoid by establishing the relatedness requirement.
What about log rolling? I mean, you could have, let's add some. Could they have added pensions, paying for pensions to this? Could you have done that?
So what the court has said is we asked.
I'm just asking, could you, under your theory of relatedness, which is they're operationally related, could you have put pension reform, solar energy, anything you wanted in there?
Your Honor, only if a petition is not confusing.
Well, this
And
isn't
also
confusing.
doesn't misuse voter assent, would this court find that it's sufficiently related under the
Well, but,
relatedness test?
no,
And it sounds like,
No, I'm just curious. Why not add energy, health care, pension reform? Those
as the
are all
court
good.
has held, questions as to scope and policy choices for a petition are for the petitioners. The original signers.
No, I'm not asking
Yeah.
whether, I'm just asking legally, are those operationally related if they were added?
I think we'd have to ask, does that misuse voter assent, such as we saw in Gray? Are you putting together such public policies that it either is so abstract that the policy is meaningless?
Not abstract, it's just different items than you picked.
If it passes the test, then I suppose they're related. That's not
So
the
there is no.
public policy in this
So
petition.
the operational relationship is the relationship between raising money and expending money.
The way this petition works is without the tax, the purposes can't be achieved. And without the purposes, the tax is meaningless. The
I
purpose of this
get that
petition is to
completely.
create the new revenue stream so that there can be new funding for education, transportation. The original signers chose transportation education because we believe they're the key to social mobility and they lay the foundation
You take
for
out,
inclusive
could you
growth.
take out transportation and put in affordable housing?
I think you can under the relatedness test, so long as, again, it's not confusing and it's not a misuse of voter assent.
Well, what weight, if any, do we give to political statements that were quoted in the briefs tying this increased potential tax increase to these mother and apple pie issues to increase voter acceptance?
I don't think, honestly, Your Honor, they're not I'm here to represent the original signers, and I can't speak to what politicians have said for why they voted in favor of this petition.
Do we ignore what was said about the petition?
I don't believe they were the drafters of this petition, or, again, they're not the original signers of this petition. They might support it for whatever reasons.
Some of them will be interpreting the application of the petition, won't they?
I think that's right, Your Honor, because this petition is subject to appropriation. The legislature indeed will have broad power to implement
And that
this
raises
petition.
another question for me, which is that, do you think that the voters will understand what subject to appropriation means in this context, which is that if they choose not to appropriate it, the money will just sit there?
I think they will, Your Honor. In both Gilligan and Ames, this court addressed just that question when there was a challenge to the summary. And the court noted that subject to appropriation, a reasonable voter would understand that that means contingent upon legislative action. So yes, I do think voters will understand that.
And they'll understand what happens to the money that's raised, that it will go nowhere.
Well, that's not our expectation, obviously. It
Well, I
would
know
be
you
extraordinary for the
expect an
legislature not to.
appropriation, right?
Yes, Your Honor. And I wanted to return to the
Can
question about law
can I ask, I want to get back to you for a second. So your relationship between education and transportation, forget about the politicians for a second, but why are they related in the petition? Why are they picked, those two, from your perspective as the sponsor?
The original signers chose education and transportation because we believe they are the keys to social mobility.
So that's their relationship? I'm just trying to, I'm
And I
trying to
would
get
add,
back
Your
to
Honor,
the legal
we also
standpoint.
chose education and transportation, as is noted in footnote 23 of our brief. These are chronically underfunded government services. Time after time, government entities, blue ribbon commissions, have found that these two core government services, which are the key to social mobility, have been underfunded. Therefore, the original signers have put forth this petition, which we hope will go to the people.
I'm just trying to, again, the legal principle for their relatedness is what? Just, I'd like you to encapsulate, because that's what we have to analyze, right?
Yes, yes, it
We
is,
need
Your Honor.
we need to define a relationship between education and transportation, don't we?
Actually,
Okay.
no, I don't believe that transportation and education must be related to meet this court's relatedness requirement. However, we believe they are for the reasons I just explained. This court's test under the relatedness requirement is to ask, one, is it confusing? We ask, could a reasonable voter coherently read the question and vote yes or no?
But
There's nothing
there's
confusing
a difference
here.
between confusing. The standard isn't comprehensible, right? It's coherent, right? Is there a unified policy that the voters are being asked to vote on, not whether the voters understand it? I mean, they absolutely have to understand it, but that's sort of the beginning. That's not the end of the analysis, right? It needs to be a coherent, unified policy that you're voting on.
And I think the completion of that thought is so that a reasonable voter could vote yes or no. And there's no doubt that a reasonable voter would be able to look at this question and know, I'm being asked, do I want to impose a tax on high earners to spend more money on transportation and education? We see this as a unified policy.
Well,
Again,
suppose they do want to spend it on both, but the legislature only appropriates it for one of them.
and that's the legislature's prerogative, Your Honor.
So then, why is that not confusing to the voter?
Again, this court has said in Gilligan and Ames, when the phrase subject to appropriation was included in Gilligan for a cigarette tax to be spent on the health fund, and in Ames for a tax on oil and hazardous waste to be spent on hazardous waste cleanup, a reasonable voter knows when they see subject to appropriation, it means contingent upon the legislature's action.
But a reasonable voter understood in the education proposals that it was a core curriculum and a standardized test. They understood there were two parts to it, but we said they were two unrelated. A reasonable voter would have understood in the Greyhound that we're protecting against animal abuse, and we're also protecting against, and we're also ending dog racing. They would understand those things. We just thought they were two
That's right.
public
That gets to
policy
the second question the court asks when it does a relatedness review, and that's, does this petition misuse voter assent? Does it engage in log rolling, as Your Honor mentioned earlier? And the answer with this petition is absolutely not. What we had in gray was a petition which simultaneously would have ended the core curriculum, combined with a completely different policy about the annual publication of MCAS test results at likely a significant cost. What the court said was, there hasn't been a unified statement of policies submitted, public policy presented, that's not so abstract that it's meaningless here.
So what's the unified public policy here?
Again, it's to raise a tax on high-income earners to spend more money on education and transportation.
Right, but
It's so simple, the whole
what kind
thing's
of
in.
policy is that? What, if you had to label that, what would you call that policy? Is it, as you mentioned, a social mobility policy? Because those things are applications, I'm not sure they're policies.
We believe it is a policy choice to spend more money on education and transportation through this new revenue stream.
Why don't you think lots of voters are going to come out of the voting booth and say, heck, I can't believe it. I just sat there. I want to have increased spending on education, but I just don't think it's a good idea to be raising taxes and just leave the reasonable voter just leaving there really frustrated.
This court has said that a petition that presents a voter with a question where perhaps they support one aspect and not others does not mean it doesn't meet the relatedness test. We saw that just 2 years ago in Hensley and in Abdow. All that's required to meet the relatedness test is that a reasonable voter either doesn't suffer voter confusion and isn't a misuse of assent. And I would like to address the log rolling.
But Abdow is a unified gambling proposal, right? It involves 3 different types of gambling. It seems different than this. But maybe I'm missing the. I mean, in the other case you cited, what were the facts of the other case?
In Hensley.
Right.
Hensley was the marijuana case, Your Honor.
Again, it's all about a coherent marijuana vote. Because an initiative, unlike the legislature, you can't amend or, adjust. The voters have to make one choice. So we've tried to make them make one coherent choice, haven't we?
There's nothing confusing about this question.
But it's not confusing, but somebody could be in favor of more education spending and not in favor of transportation spending. They could be in favor of transportation spending, but not in favor of a graduated income tax, couldn't they?
And this court has held that doesn't mean it doesn't meet the relatedness test. That's
Where did
simply,
we
that's a
ha- where
voter
did we hold
decision.
that?
Going back and forth between this unified public policy concept and related, and then meeting the related test, we end up in a circle. It feels to me that there's no clear answer coming as to how do these things relate. If greyhound racing and animal abuse aren't sufficient together, and if the education cases weren't, those 2 issues weren't sufficient, how are these 2 things, what is their common policy purpose?
Your Honor, I think if I could speak to the Carney case with the greyhound racing, the reason this court found that petition did not meet the relatedness requirement is that it found that it was quintessential log rolling. Log rolling, by definition, packages together several proposals when at least one of them wouldn't be approved standing alone. The presumption by the plaintiffs is that there's something in this petition that couldn't stand alone. We dispute that premise. There's absolutely no evidence of that. Secondly, even if we were to look at the 1994 petition, the last time a graduated income tax was on the ballot, which this petition is not a graduated income tax, there are several differences. The 1994 petition would have provided the legislature with unbridled authority to spend the money on whatever it chose and create different tax rates. This petition is just the opposite. It's incredibly narrow. It's incredibly clear who's being taxed, at what rate, and how the money's going to be spent. In Carney, the court noted just 6 years ago, the exact same petition, verbatim, had been rejected by the voters. And all that had happened was packaging on a very popular provision which enhanced the criminal penalties for dog abuse. There, the court found this is log rolling. This is a misuse of voter assent. There is nothing in this petition which puts voters in that position of a misuse of voter assent. And similarly, in Gray, the court was troubled by the combination that didn't bear a relationship to either eliminating the Common Core, which was the title of the summary of that petition, with the publication annually of MCAS results. And likewise, I think the Unified Statement of Public Policy, the court said, just had education in it, and the court said that's just too abstract. It's so abstract that it's meaningless. We submit there's nothing abstract about this policy. It's not meaningless, it's meaningful, and it's quite clear exactly what the policy is.
All right, thank you. Mr. Rice? Mr. Hahn Rice, I'm sorry. Ms. Rice.
Your Honor, thank you. Good morning, Mr. Chief Justice. May it please the court. Juliana Rice, Assistant Attorney General for the Attorney General and the Secretary of the Commonwealth. With me is Assistant Attorney General Daniel Hammond. I think part of what the court is struggling with is the unprecedented nature of this petition, and Attorney Martin is absolutely correct when he says a petition of this level of breadth has not been before the court and has not been the subject of an Article 48 challenge. But nonetheless, it is our job to measure it against both the requirements of Article 48 and how those requirements have been implemented by this court. The operational structure of this petition is the same as our current system of fiscal management. It proposes a broadly based tax to support fundamental obligations that state government has always undertaken and always will undertake. Schools and roads have been paid for with public dollars since the Commonwealth began, and the income tax is how those dollars are raised. This proposed amendment would make more resources available from the income tax, which is, of course, the most general exaction there is, for the priority areas chosen by the petitioners. And they are free to express their policy preferences through the direction of dollars.
Preferences, plural. Those are two different preferences, aren't they? And they're not related to each other. And I mean, I guess from the AG's perspective, could they have put anything in here? Any public policy that's legitimate for the legislature to spend money on? Health, energy, you name it. Could they?
Well, Your Honor, we have to look at the relatedness analysis that's been generated, but I think the best answer to that is that there's no question, nobody would raise a relatedness challenge to this petition if all it did was impose this increased income tax. And of course, those additional revenue dollars would need to be spent on proper public purposes, as all public dollars need to be.
So that's the first one. So in answer to the Chief's earlier question, your view is you can impose this type of increase. I get that far, but then how do we, and you could have had it without any specifics, but now you've only chosen two expenditures. They're arbitrary, right? They could be any two good expenditures, couldn't they?
I would look less at the subject matter of the proposed expenditures and more at the breadth of the spending discretion retained by the legislature. Within the bucket of public policy purposes that the legislature can choose to spend money on, this court's relatedness.
So there needs to be no relation. Anything legitimate could be included.
I would not say that, Your Honor. What I would say is that under this court's jurisprudence, most specifically in the MTA case in 1981, this court has held that within the range and array of subject matters that petitioners can choose, they get to make those choices as long as the end result in terms of a petition that's being laid before the voters is coherent and not confusing.
Well,
I think when you get
there's a difference between comprehensible and coherent. I think everyone understands how this works. There's not a danger that the public is being misled, but the public is having to make three different choices in one provision, and they don't seem to be operationally related except for they were related by the sponsors.
I think, Your Honor, unlike the dissimilar subjects at issue in the Carney case, which were two discrete narrow policy programmatic changes that the petitioners wanted, unlike the different proposals at issue in the 1996 opinion of the justices that related to two different branches of government, and unlike the two
You think that education and transportation have a closer relationship than core curriculum and issuing the standardized test questions, testing core curriculum?
I don't think they need to, Your Honor, because these provisions, this comprehensive whole that's being presented, everything moves in the same direction. A large, broadly based tax to support broad policy areas, leaving the specific spending choices up to the
But
legislature.
isn't that,
Go ahead. Could the legislature apply the money to decide to increase charter schools?
It could, Your Honor.
isn't this bumping into Article 63 at some point, though? Because we're talking about setting a tax, and we're talking about two major areas for public policy expenditure. And you're setting the tax, and you're picking two very important areas of spending as a matter of public policy. And isn't that what the legislature does under Article 63?
The legislature certainly does do that, and the legislature will retain its discretion to do that under this proposal. What this court looks at in determining whether a proposed initiative petition goes too far toward making a specific appropriation, thereby usurping the legislature's authority under Article 63, it looks at the level of discretion to make spending choices that is retained by the legislature. And historically, when power is given to the legislature or direction is given to the legislature subject to appropriation, this court has most often concluded that that language saves a petition from making a specific appropriation. Even if this court in the future, in addressing if an actual dispute arose about the implementation of this provision, if it were adopted, even if the court departed from that and concluded that those spending requirements were, that the court could declare that the legislature needed to observe them, the breadth of the spending choices that would be retained by the legislature would still be of a nature that this would not approach a specific appropriation that has been prohibited by the court by Article 48.
I mean, do you agree that this may or may not result in any overall increase in education and transportation spending?
I do agree.
So, at some level, the fact that it's being devoted to, I mean, what essentially is this is a tax increase whose revenue will be dedicated to two purposes, and the legislature will have to spend that dedicated funds for those purposes.
If this court, in reviewing an implementation dispute, were to conclude that subject to appropriation in this context means something different than the court concluded in the AIM case, in the Gilligan case, in the Mazzoni case, and if it were implemented more like the 1992 Mitchell case, in which this court reviewed a challenge to spending under Article 78, which contains similar language to subject to appropriation, that spending shall be as the general court shall direct. And the court in that case concluded that had a violation been, or the court was ready to issue a declaratory judgment that the legislature was not acting in compliance with that amendment, if in fact...
You've lost me. I don't know where you're going with that. This creates a tax whose sole purpose will be to be spent on one or of two or both purposes.
Yes,
correct?
Your Honor.
And the legislature has absolute discretion as to whether it spends it for one purpose or the other purpose.
Yes, Your Honor.
And if there were simply a tax that provided for a millionaire's tax with no limitation, the legislature could spend that money for any purpose.
Any proper public purpose, yes, Your Honor.
So what this bill does is it says we will create this revenue, but we the people will direct that it be spent on only one or two purposes.
Yes, Your Honor.
And why is that two questions? Why is that not a single question? Do you want a tax increase to be devoted to one of two purposes?
I think it certainly can be viewed as a single question. I think the concern that is coming up is what about the voter who doesn't have children but rides the MBTA? and has a lot of concerns about the perceived underfunding of the MBTA. And this court said in Hensley that it said in Abdow that that is a rabbit hole that is, we should not go down, imagining the hypothetical voter who would have strong feelings on one side or the other. And the court said in Hensley that if such a voter has strong feelings one way or another, it is up to that voter to weigh those competing impulses. As long as a coherent policy is presented that they can evaluate and understand, they have to decide on the whole, which do they prefer, a yes or no vote?
I mean, I think we've said the key issue is it fair
Yes.
to say yay or nay?
Yes.
And it's not fair when you say, do you wish for there to be a core curriculum? And do you wish for there to be complete transparency with regard to MCAS results, so you need to create a separate MCAS test every year? That was viewed as two separate questions.
Yes, Your Honor.
But this question is, do you wish a tax increase devoted to one of two purposes? And why would that not simply be a single up or down question?
I think you can certainly view it as such.
Can you address, the amicus brief for the Chamber of Commerce talks about the example of California. Can you explain why we will not face the problems that California faces if we start down this road?
We will not face the problems that California faces, Your Honor, because the legislature under Article 48 has to retain ultimate spending discretion. And this proposed amendment would keep that spending discretion. That spending discretion is also in place in Article 104, or Article 78, amended by Article 104.
Well, but California got itself in trouble. For example, right, they created an initiative that required 40% of the state budget to go to education, right? I believe, I may be oversimplifying that,
Yep.
but that's my recollection of that.
I would say I'm sorry, Your Honor.
And why couldn't that happen here, too?
It could not.
That you, instead of doing a millionaire's tax, you increased everybody's taxes 4%, generating, and all of that money should go to education. Wouldn't that create the California type of situation?
Yes, Your Honor. I do not believe that the Attorney General would certify such a petition, nor would this court
Why not?
uphold its validity, because, in the words of the Bates case, that would be segregating a portion of money from the public coffers, and in the words of the 1937 opinion, committing it permanently to a specific public use.
Well,
That's not what this petition
I
does.
don't understand how this doesn't do that, though, when it says subject to appropriation. It's still segregated for education and still segregated for transportation. Why wouldn't it be the same?
It may or may not be, Your Honor, depending on how this court were to view the terms subject to appropriation in a challenge that might be raised in the
It
future.
doesn't just say
This
subject
court-
to appropriation. It says subject to appropriation only for these purposes.
Yes, Your Honor, and this exact argument was raised to the court in the 1992 AIM decision, that the funds at issue there shall be used only for the specified purposes, or possibly solely. And the court in the AIM case concluded that the use of those words was tempered by the inclusion of the subject to appropriation language, and those words did not thereby create a prohibited specific appropriation.
And does it matter to you that the amount at issue is only 10% of what we're presently spending on these two purposes?
Yes, Your Honor, I'd just like to correct the number. The numbers that I think the parties are all in rough agreement about is that current spending in those areas is 10 to 11 billion, or about 25%, slightly under 25% of the budgets over the last few fiscal years. What that fact does is mean that it is less likely that an actual dispute may arise over the implementation of this amendment if it is adopted. But it does not bear directly on the constitutionality of the question. I agree with my brother that the constitutional analysis would need to be the same regardless of those background facts.
So if we were to be allocating 80 billion for the sole purpose of education and transportation, your view would be the same?
My view on whether it created a specific appropriation that would be barred by Article 48 would be the same.
All right, thank you.
All right, thank you very much.